All right, welcome to The Explainer. Today, we're diving into a really powerful and honestly fascinating safeguard in India's justice system. It's the High Court's ability to quash a criminal case. And quash literally means to just stop it completely. Think of it like a critical safety valve on the entire legal machine.
So let's just imagine for a second. What if you were wrongly accused of a crime? Someone names you in a complaint. The police file that FIR, the first information report, and bam! Just like that, your life is turned upside down. You're suddenly staring down the barrel of a long, incredibly expensive, and just emotionally draining legal fight for something you didn't even do. It's a terrifying thought, isn't it?
Well, thankfully, the law has this crucial escape hatch built right in. The High Court has the power to step in and stop an unfair prosecution dead in its tracks. And this power to quash a case, it's genuinely one of the most important protections any of us has against the law being misused.
Okay, so with India's new criminal laws on the horizon, you're probably wondering, has this power changed? Is it still there? And the answer, the good news, is that while the law has a new name and a new section number, the power itself, it's exactly the same.
So you can see here, the old law, Section 482 of the CRPC, and the new one, Section 528 of the BNSS, they are practically word-for-word identical. Now, this isn't just some boring legal technicality. This is a huge deal. Why? Because it means that all the decades of Supreme Court judgments, all the legal principles that have been built around this power, they're all still totally valid. It gives us stability and predictability, which is exactly what you want from the law.
So what does the law actually mean when it talks about inherent powers? It's a really cool concept, actually. The law isn't giving this power to the High Court. Instead, it's just recognizing and preserving a power that the court already has simply by virtue of being the High Court. It's considered a fundamental part of its job to stop injustice. It's a check and balance that's baked right into the system.
Okay, so we know the power exists, but when can a court actually use it? Well, the definitive guide, the absolute Bible on this, comes from one single landmark Supreme Court case, State of Haryana versus 𝘲𝑗𝑛 Law. This case literally wrote the rulebook that high courts still follow today.
And what 𝘲𝑗𝑛 Law did was lay out these 7 key scenarios. Think of it as a checklist for the courts. You know, a case can be quashed if the FIR on its face doesn't even describe a crime, or if the allegations are just so wild, so absurd, they're impossible to believe. Now, for our purposes, we're going to zero in on 2 of the most common and, frankly, most interesting grounds, when a civil fight gets dressed up as a crime and when a case is filed just to get revenge.
All right, let's dig into that first scenario, civil disputes in disguise. And believe me, this happens all the time. You've got someone trying to use the full force of the criminal justice system, the police, the courts, to sort out a problem that has no business being there. We're talking about things like a business deal gone wrong or a fight over property.
This quote just nails it, doesn't it? Giving a purely civil dispute the cloak of criminality. It's a tactic. It's a way to strong-arm someone. See, people do this because they want to skip the long, drawn-out civil court process. Instead, they try to use the threat of a criminal case and maybe even arrest as a weapon to get what they want. And the courts? They are very, very aware of this game.
So where is the line? I mean, what's the difference between a simple breach of contract and the crime of cheating? Well, look at it this way. If you just fail to pay a bill, that's a civil problem, a breach of contract. But if you sign that contract with a dishonest plan from the absolute get-go, knowing you are never going to pay, that's when it crosses over into criminal territory. The entire case boils down to your intent at the very beginning. And the courts have been crystal clear on this. The police are not your personal debt collectors.
So if dressing up a civil case as a criminal one is a common abuse of the law, the other major reason for quashing a case is, honestly, even more personal. This is when the justice system isn't just misused, it's weaponized, used as a tool for pure, simple revenge.
And you see this a lot, unfortunately, in matrimonial disputes. The courts are incredibly cautious here. It's sadly pretty common to see these really general, sweeping allegations, what the courts call omnibus allegations, that don't just target a spouse, but drag in their parents, their siblings, maybe even cousins who live in another city. If the complaint doesn't say exactly what these other family members supposedly did, the courts will often just quash the case against them. They see it for what it is, a blatant abuse of the process.
I mean, check out this case, Suman Mishra. The timing tells the whole story. A husband files for divorce, and then, just 2 months later, Boom, his wife files a criminal complaint against him. The Supreme Court looked at the situation and saw right through it. They called it a malicious counterblast, basically a retaliatory strike, and they quashed the entire thing.
But, and this is a really important but, this power to quash is not a blank check. It's not a get-out-of-jail-free card. It's a very carefully guarded power, and there are firm lines that the courts will not cross. There are absolutely situations where a high court will refuse to quash a case, even if all the people involved have settled and want to drop it.
The key distinction here, the one the courts always make, is between what they call private wrongs and public wrongs. So a private wrong affects individuals. Think of a matrimonial dispute or maybe a minor financial tiff. In those cases, a court might quash it if the parties settle, to promote peace. But a public wrong? That's different. That's a serious crime that harms society as a whole. We're talking about murder, rape, major corruption, or huge financial scams. These can't just be settled away privately. The state has a duty to prosecute these crimes for the good of everyone, and that duty trumps any personal agreement.
So when you step back and look at the whole picture, what's the ultimate point of this power? It's not really about any single case. It's bigger than that. It's about being a fundamental safeguard for our entire justice system. Really, this power has three core goals. First, stop the legal process from being abused. Second, make sure that, in the end, justice is actually served. And third, give teeth to court orders so they're actually followed. It's like the judiciary has its own built-in, self-correcting mechanism.
Ultimately, it's all a very delicate balancing act. This power is a critical filter. On one hand, it's there to protect innocent people from being harassed and to stop the courts from getting bogged down with malicious cases. But on the other hand, it has to make damn sure that people who commit serious crimes against society face justice.
And that really leaves us with one final, and I think crucial question. We've seen how the power to quash is this vital check against injustice. But who checks the checker? What are the safeguards for this safeguard? How do we make sure that this incredibly powerful tool is always used for good and never, ever becomes a loophole for the guilty to walk free? Thanks for joining me on The Explainer.